I'm going to discuss Learning Unit 3. I'm in your study guide, page 23, and this is the South African legal profession. Okay, now this, and I keep on saying this is important, but yeah, in this part we discuss the fit and proper person. Now, if you go back to previous exam papers, you will see that it is asked nearly every time. And students do not perform well, and I do not understand why, because all the information is there. But once again, I think you think it's too easy, and then you do not have enough facts to give for 30 marks. So the first thing that you need to know is on page 23, and now remember the Legal Practice Act, because on that page we still speak of the Attorneys Act and the Admission of Advocates Act. If you answer that in the exam, it is fine. We will mark it, it is correct. If you refer to the Legal Practice Act, excellent, because it's still a requirement in the Legal Practice Act, so it didn't disappear. So it was in the Attorneys Act, it was in the Admission of Advocates Act, and it is now specifically also in the Legal Practice Act. So there's a requirement for you to be a fit and proper person. But now, what does it mean to be a fit and proper person? The first thing, if a question like this is being asked, is to say that it is nowhere defined. Even though it is a legislative requirement that you need to be fit and proper, it is not defined. So what does it mean to be a fit and proper person? Then it is on page 24. You must now go through all the rest of the pages, and you must underline and you must highlight, so that you can answer a question of 20 to 30 marks. So I've said you will start with it is a requirement. It is not defined. It is in the Attorneys Act, it is in the Admissions of Advocate Act, and it is now in the Legal Practice Act. Because it's not defined, it is a subjective decision of the High Court, and that comes from common law. So in other words, you will apply to be admitted to start your articles, either as an attorney or your pupillage as an advocate. You will have to fill in forms. It is a notice of motion that someone will take on your behalf, and you will apply to court to be admitted. And it is in the discretion of the court to decide whether to allow you or not. Obviously, will they look at things, do you have a previous criminal record? And I want to interrupt myself here. That is not necessarily that you will never be allowed if you have that. It must just be investigated and you must be truthful. But yes, so why is this necessary? Go through your study guide and see why do they have that character screening. Was it tested constitutionally? Yes, it was, in 2 cases, and this can be a separate question, in the Kleinhans case and the Mashaka case. How was it applied in the past? In the past, in apartheid, there were discrimination against lawyers. And you will see that Gandhi was never seen as fit and proper just because he was Indian. Madeleine Wookie, she was not fit and proper because she was a woman. Then Fisher, he was part of the activities in apartheid, the Defiance campaign, etc. And he was struck off the roll of advocates. You need to give me these examples, but do not elaborate. In other words, just say Gandhi because he was an Indian, Wookie because she was a woman. Do not talk or tell me Gandhi's whole life. That will not earn you any marks. So everything that I'm saying now is relevant to the answer of being a fit and proper person. You will start on page 23, you will add page 24, you will add page 25, because there it even goes to Prince. You will go to page 26, and on page 26, be careful, this can be a separate question. Was the fit and proper person screening test constitutionally tested? Yes and no. Explain. Then you have to discuss the Kleinhans case and the Mashaka case. You need to indicate to me, one was the interim constitution, what sections, what was the issue, and the other was the final constitution, which articles was in question and what was the result. Be careful, the Roseman case is not necessarily based on the fit and proper person test. It is more based on the division between the work. In the Roseman case, on page, 26, my eyes. On page 26, the Roseman case said it is fair that we have attorneys and advocates. So I'm making a comment here. According to the Legal Practice Act, we will basically now have 3 professional divisions. We will have attorneys, as we know it now, who works directly with clients, and they will carry on doing that. They will need a fidelity fund certificate and they will have a trust account. The advocates will now divide into 2 groups. One group will become advocates with a trust account. In other words, those advocates will work or do the same work as attorneys, but as advocates, but they will work directly with the public, but they will have to prove a trust account. And then we will have advocates that is purely advocates as we know them now, that will be briefed by an attorney. And it will still be a referral system. And they will stay advocates, litigation specialists as they currently are. So we have that 3 groups. So the Roseman contested or asked the question, is it fair to have a division between attorneys and advocates? And that case said yes. But just remember that the scenario have now changed with the Legal Practice Act. Okay, then the regulation of a lawyer's life, page 27, 28. You can go through that. What is more important for me is on page 28. You get that shift from character to duty. Now this forms part of the fit and proper person test. So if the fit and proper person test is asked for 30 marks, you must cover the whole lot. So you will start by saying that it is a legislative requirement. It is a common law discretion of the court. You will refer to the acts. You will say that it is not defined. You will say why is it necessary to have a character screening. You will say that people didn't always like it. It was tested 2 times in the Constitution. You will say that that test was misused in the past. You will refer to Gandhi. You will refer to Wookie. You will refer to Fisher. You will refer to Prince. And then you will even carry on and you will now add what is on the next pages. You will add Krauss and Mandela. And you will make the comment that in these 2 cases they focused on the character purely. Then comes Hassim, Moseneke, Makubela, Matthews. All of those, there was a shift and they did not focus on the character anymore, but they focused on the duty to uphold the law. That is when the question is for 30 marks, discuss the fit and proper person requirement. And you will see that it has been asked, I think, the last 3 semesters. So maybe we will not ask that specifically again for a long question, but we might in between. Remember, we can ask, how was it constitutionally tested, the fit and proper person test? Has been asked last year, may be asked again. Kleinhans, Mashaka, 5 marks, 5 marks, 10 marks. Or we can ask you to compare, for example, Krauss and Mandela with Moseneke Makubela. Then Krauss and Mandela is the character test. Now if a question like that counts only 10 marks, do not discuss Mandela's whole life on 2 or 3 pages. It is not worth it. Short. What did Mandela do? What happened? What happened in court? Same with Krauss. On the other hand, you have Makubela, Moseneke. What did they do? What was the judgment? The point we're trying to make is Mandela and Krauss, the character test was applied. Moseneke and Makubela, the duty test was applied. You need to know that difference. So we've asked Mandela, Makubela in the past. We can also ask Mandela, Moseneke. So it's still the same. Just make sure that you then know what Moseneke did. Okay, so everything that I've said now, it's on page 29, page 30, page 31. Even in this new study guide, you've got that catchphrases to the left of the study guide, so it's easy to follow. It goes on page 33, there's a discussion of Moseneke, there's a discussion of Makubela, and then on page 34, there is a discussion of Prince. Now, also Prince can be asked as a separate question. So if we ask anything concerning religion, then you answer Prince. You give the facts, what he did, and the judgment eventually in the Constitutional Court. And if you know it, then you will even add and say that the use of cannabis privately in your home is now allowable. But we will not penalize you if you do not say that. So if you add it, it's good. If you don't, you will not lose marks. So Prince can be asked as a shorter question. And then we can also ask to compare sort of Fisher and Prince. Fisher had a political issue that drove him to do what he did, and Prince had a religious issue. You give the facts of Fisher, the facts of Prince, and then you compare the two and you come to a conclusion. Do you think they had the same issues, etc., whatever we ask. Then we come to page 35, and that goes more or less with Prince. Now, what is also nice to ask is to ask Prince and combine it with postmodernism. Remember, it was for a long time illegal to have cannabis, rule-based. Postmodernism, everything goes, we celebrate differences. And then the Prince case. So do you see there's a sort of a connection between postmodernism and Prince? So we can combine a question on that. And then we come to civil disobedience. And some of you might have heard that a person has tweeted that we should actually all stop paying our taxes because of everything that's coming out in the Zondo Commission or whatever. Now, a call like that, and should we respond to that, will be labeled civil disobedience. In other words, civil society will now stop doing something to indicate that they are not happy with the way things go. The question can now arise, may you as a lawyer, attorney, advocate, whatever, take part in civil disobedience? Yes or no? Now, first of all, when a question like that is asked, whether you as a lawyer may participate, you will first start with what is at the bottom of page 35. You will see there we list when civil disobedience will be acceptable. And there's 1, 2, 3, 4 dots. So it's only 4 things. When the laws are immoral, when it is against certain religious beliefs, when the law is unjust, as it was in apartheid, and when utility so dictates. In these circumstances, you are allowed to embark on civil disobedience, but never you as a lawyer. In other words, the Freedom Front Plus or the EFF or a civil society can come and see you as an attorney or an advocate and get advice on civil disobedience. How does it work? How do they go about it? What is the law about it? And you can give them advice, but you cannot go with them and toy, because your obedience is towards the court and it is higher than that of your clients. So we will come to that part in the next learning unit. So if a question like that is asked, that there is a person asking that everyone should stop paying taxes, and they come to you as a lawyer to ask your advice, how will you handle it? You will first of all say that civil disobedience is acceptable in exceptional circumstances, and it is those four. And then you will also argue that you as the lawyer cannot partake, but can give advice only. Okay, that is then page 35. Let's go to 36. You can also, remember we're still busy with the legal profession and whether you are fit and proper or not, and I said to you that could be a question of 30 marks, although it has been asked quite a lot, but we can ask shorter questions in that chapter. We can also ask the question, how can you be removed? Okay, now you have been allowed to practice, and you've practiced long as an attorney or an advocate, and then suddenly things go wrong and you need to be struck off the roll. In other words, you need to be prevented from carrying on doing your business. And this is a little bit of a new part in the study guide. So those of you writing supplementary, accredited or special exams, just take note, we have elaborated a little bit on this part, which of course makes it also nice for possible questions. On page 37, the case of Yassat. Mark that. It is the case of Yassat, because in that case it was indicated that there is a 3-stage inquiry that you must go through before a person can be struck off the roll. You can go, it's dot 1, 2, 3, it is there on page 37, the case of Yassat. Then you can read through the rest, the Swanepoel case, the Mabasu case, be able to provide that as possible examples when you talk about striking a person from the roll. Now, if the person has been struck off the roll, can that person ever be reinstated to get back on the roll, to practice again? And that starts on page 38. And you need to at least explain to us for 3, maximum 5 marks, how can you be readmitted? And you will get that on page 39. You can refer to the Attorneys Act if you want to. It will still be acceptable. You can refer to the Legal Practice Act and explain to us how the court decides to readmit a person. And it is basically in the case of Kaplan, page 39. Make sure, go and underline, go and highlight. There are 3 specific things pointed out in that case that the court considers when you apply to be readmitted. Then if we turn over page 40, 41 and 42, the last part of Learning Unit 3 is the Legal Practice Act and the Code of Conduct. Of course, this is not the whole act. This is just a little part of it, and reference is just made to the code. When we designed this new study guide, the act was still not finished, and there was a time limit, and we had to submit the study guide. So we've put it in, and then since the guide was published, the act is now in force, although, as I've indicated, it has an interim phase to get everything in place. But you should at least know, as it is on page 40, what is the purpose of the act, because this will now drive the whole legal profession in future. So what is the purpose of the act? And I've seen 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, a possible 15 marks. What is the purpose of the act? Make sure that you understand that. You will see there that section 24 of the act, it is page 41, refer to the fit and proper person, and then there's a code of conduct for legal practitioners. Just take note of that. We will do that in detail in later years when it's all finalized, but on page 42 possible shopping list question, 9 bullets. What is expected of legal practitioners? That is general, it is now specifically in the new code, but it is also, it used to be in the attorney's code and in the advocate's code. But be careful, this is once again an easy waffling question. Make sure that you go to page 42 and you know these 10 things off by heart, and do not just think what you want to answer. If we ask what is expected of a legal professional, those 10 things on page 42. Okay, this is the end of Learning Unit 3. We're going to stop here. There will be a new link for Learning Unit 4.